New Mexico Real Estate Basics, page 16. What if a buyer wants to use a post-dated check or a diamond ring for earnest money? In New Mexico, NMREC rules do not address post-dated checks or anything other than cash or an immediately cashable check. Brokers should be careful to clearly communicate any of these situations to the seller prior to acceptance of the offer and to ascertain that the nature of the deposit, as well as any obligations of the broker in handling the item, is clearly stated in the offer to purchase. What are the rules governing a trust account? Unless there is a written agreement between all parties to the contrary, trust accounts in New Mexico may not earn interest. The rules do not allow for establishment of special or custodial trust accounts by written agreement, and these may be interest-bearing accounts. Trust funds to be placed in a custodial account first must be placed in a regular trust account and then transferred to the custodial account. The qualifying broker must keep detailed records of all funds received. The qualifying broker is responsible for indicating the date received and deposited, from whom it was received, and for which property transaction. Finally, the broker must clearly indicate the nature of the funds, that is, earnest money deposit, rents, security deposit, owner's funds, and so forth. Likewise, the qualifying broker must maintain a detailed record of all funds dispersed. Records maintained by the broker must be clearly indicate the following: check number, date of payment, payee, amount and purpose of payment, and the related property transaction. A check numbering system with a check register must be used for control purposes, and voided checks must be retained. Trust account, bank records, and office records must be reconciled monthly. The broker must keep these records for at least 3 years. How can a qualifying broker open a trust account without any trust funds? The state of New Mexico allows the qualifying broker to open trust accounts using personal funds not to exceed the required minimum balance in order to meet the minimum balance requirements of the bank necessary to maintain the account and avoid charges. Such use of these funds is not considered commingling. What is commingling of funds and why is it illegal? By definition, commingling is mixing personal funds with those belonging to other people. To repeat, the qualifying broker's personal funds are to be used solely for paying expenses directly related to the maintenance of the trust account. The problem with excess personal funds in the broker's trust account is simple. If the qualifying broker commingled personal funds into this account and the IRS froze the broker's accounts, then the trust account would be frozen too. The same thing could happen if a sole proprietor owned the brokerage and suddenly died after commingling personal funds into the trust account. The commingled brokerage trust account could end up in probate. In either event, all closings would be tied up for a considerable length of time.